So I'd like to introduce the participants for our closing keynote today. I'm going to introduce Judge Preska briefly, and then she will introduce Judge Keenan. We are so honored here at Columbia to have these two federal judges here with us today. It's wonderful, and we're so appreciative of both of them for taking the time out of their hugely busy schedules to travel uptown to speak with us. So Judge Preska is a United States District Court judge in the Southern District of New York. She has held this position since 1992. Is that right? I'm going to question that fact, but Judge Preska was nominated to the Court of Appeals for the Second Circuit back in 2008. She served as a member of the Committee on Federal State Jurisdiction of the Judicial Conference of the United States and now serves on the board of the Federal Judicial Center. She was in private practice at Cahill Gordon, and she was a partner at Herzog, Calamari, and Gleason in 1983. She has served in so many different roles in government, and we couldn't be more honored to have her here introducing Judge Keenan. Thank you so much, Judge Preska.
Good afternoon, ladies and gentlemen. It's an honor and a privilege to be at the Global Cities Conference on Public Integrity. I must confess to you, however, that I have the easiest job of the entire day in introducing to you the Honorable John F. Keenan, because Judge Keenan is, after all, the walking embodiment of public integrity. He's worked in the public sector in city, state, and federal government for all but a few months of his 63-year career, and he's widely recognized for his preeminent commitment to public service and for his dedication to the highest ethical principles. Judge Keenan graduated from Manhattan College and Fordham Law School. He served in the Korean War in military intelligence and returned to the States in 1956. Having listened closely to his father's stirring stories of grand jury experiences, Judge Keenan applied for work at the Manhattan District Attorney's Office, so that's the Manhattan Prosecutor's Office. And I note, as someone did earlier, that you are going to hear tomorrow morning at 9 a.m. from the current Manhattan District Attorney, Cyrus Vance. Back to 1956. Because all of that year's slots in the District Attorney's Office had already been filled, the newly married John Keenan went to work at a private law firm for 4 months, his only venture into the private sector. He became an assistant district attorney toward the end of 1956, working under the legendary Mr. D.A., Frank Hogan. There, he became what Mike Armstrong, the famous criminal practitioner, called, quote, the most prominent homicide prosecutor ever in the state of New York. One of Judge Keenan's high-profile cases involved the grisly murder of 2 young women in their apartment on the Upper East Side of Manhattan in 1963. The case was known as the Career Girls Murder Case, and it formed the basis of an episode of the TV show Kojak. The police arrested and Brooklyn prosecutors charged a man named George Whitmore, a 19-year-old laborer of limited intelligence, after he signed a 63-page detailed confession. But however, Judge Keenan and his colleagues thought something was not quite right. They were troubled by certain details of the confession, including the fact that Whitmore didn't seem to know that the women were even dead. And I am just telling you, the photos of the crime scene leave nothing to chance. You knew it. So these and other details led Judge Keenan's team to the thought that Whitmore's confession was bogus. Eventually, a more likely suspect emerged, a man named Richard Robles, who was a convicted robber who also lived on the Upper East Side and was fingered by a junkie, a fellow junkie. At Robles's trial, Assistant District Attorney Keenan not only had to prove that Robles murdered the women, but he also had to prove that this guy Whitmore, who had been indicted and paraded out before the press as the killer, was innocent. And of course, that meant cross-examining the police officers who obtained Whitmore's confession when they were called by the defense counsel. And of course, all of the police officers continued to maintain that Whitmore was guilty. How hard is that? Judge Keenan also had to deal with the fact that the person who had identified Robles was himself a junkie, facing his own murder charge for killing a heroin dealer. Nevertheless, the preeminent trial lawyer, despite all these obstacles, on December 1, 1965, got a jury to convict Robles of the murders, and the conviction was affirmed on appeal. Later on, after a short stint with the newly installed district attorney of Queens County, one Michael Armstrong, Judge Keenan returned to the Manhattan DA's office as the chief assistant, a job he held throughout the rest of his tenure. Of particular interest to this group, in 1976, after some 20 years as an assistant district attorney, Governor Hugh Carey and Attorney General Louis Lefkowitz of New York named Judge Keenan as a deputy attorney general and special prosecutor for corruption in New York City. That position had been created by Governor Nelson Rockefeller, who said that it was, quote, to dispel completely any cloud that threatens the public's respect and confidence in those who uphold the law. The New York Times profile of Judge Keenan at that time began with the following quotes about him: thoughtful, careful, decent, a guy of absolute integrity, and tough but fair. And he certainly lived up to all of that. In 1979, Judge Keenan was asked to serve as president of the New York City Off-Track Betting Corporation, a job that combined his love of horses with the need for absolute integrity in the organization. And he later served as criminal justice coordinator for the city of New York. In 1983, President Ronald Reagan nominated Judge Keenan to a seat on the United States District Court for the Southern District of New York. Our court is often referred to as the Mother Court because it was the first federal court to sit under our then new Constitution on the first Tuesday of November, 1789. While on the Mother Court, Judge Keenan has presided over many important cases, both civil and criminal. For example, shortly after taking the bench, Judge Keenan was assigned the about 145 cases arising out of the deadly gas leak at the Union Carbide plant in Bhopal, India. His decision that the cases should be tried in Italy, but with American discovery rules, was called ingenious and Solomonic. Today, as we watch the ongoing trial of former Malaysian Prime Minister Najib Razak in the 1MDB corruption scandal, we are reminded that in 1990, Judge Keenan presided over the U.S. government's prosecution of Imelda Marcos, wife of the late President Fernando Marcos of the Philippines. She was tried on charges that she stole over $100 million from the Philippines and used it to buy art and jewelry and to commit real estate fraud in New York. One of the enduring images from that trial was the over 1,000 pairs of shoes in Mrs. Marcos's closet. Judge Keenan's skill as a trial judge and his reputation for fairness has spread throughout the federal judiciary. For example, in 2005, a man named Gail Nettles threatened to blow up the Chicago federal courthouse, which housed both the trial court and the appellate court. So all the judges in that district had to recuse themselves because of the threat. So the Chief Justice of the United States appointed Judge Keenan to go to Chicago and try the case. And he did so impeccably and sentenced Nettles to 160 years imprisonment, so he wouldn't try it again. Under similar circumstances, Judge Keenan was asked to try a case in the Eastern District of New York, in Brooklyn, where the defendant had tried to hire a hitman to kill a prosecutor and the judge who had presided over his conviction. I was wondering if Judge Keenan's motto shouldn't be, have gavel, will travel. Judge Keenan's vast experience, good judgment, and perfect moral compass make him the embodiment of wisdom and judgment on our court. His humility and his temperament invite his colleagues on the bench, both newer judges and more experienced judges, to seek his advice early and often. And particularly during my 7 years as chief judge, I frequently turned to Judge Keenan for advice, and he's never disappointed me. He always counseled to do the right thing, and because of his wisdom, experience, and judgment, he always suggested an elegant way to do it. So I ask you, ladies and gentlemen, to join me in welcoming the embodiment of public integrity, John Fontaine Keenan.
Thank you, Judge Preska. I'll have a little bit more to say about the introduction in a moment, but first I'd like to First, I'd like to tell you how happy I am to address this distinguished group from global cities, and I hope that you are enjoying your visit to New York and to the United States. There are wonderful things to do and see here in New York, and we want you, I'm sure this is so for all the hosts and all the participants in your panels and in your program, we want you to see the sights and do interesting things while you're here in New York. Now I'm going to tell you a story that's not in my prepared remarks, but when I received the outline of today's program from Ms. Gill, whom I've known since she was in a baby carriage, and I was already head of the Homicide Bureau, probably. Now, when I ran OTB, I had to become an expert in horse racing very quickly. So there was this winter conference down at the Doral Country Club outside of Miami, where they have that big golf tournament every year. Well, this was a beautiful day, and there were 4 speakers this morning. I was the third. And there were windows in this room, and it overlooked the 17th green, and it was a gorgeous day in February. So there were about as many, maybe a few more people for the first speaker than are here in the room now. He finished. Several people got up and left. Next came the second speaker. She finished. More people got up and left. I was the third speaker. There was only one more person there. I looked and I said, "Thanks very much for staying." He said, "Thanks hell, I'm the fourth speaker." Now, I tell you that story because it's so nice of you all to remain here after that excellent panel that I just heard. Now, recently I heard a former member of our court speak. That was President Bush 43's Attorney General, Michael Mukasey. And he said publicly that federal judges never tire of being praised, that they lap up adulation like a puppy does its milk. And so, Judge Loretta Preska, would you please repeat those remarks from that introduction? It really was something that my mother would have believed and my father would have wished were true. Someone once observed that trial lawyers are a rare race of orators, some of whom are far more famed for the exaggeration of their remarks than the accuracy of their reasoning process. That certainly could be said of that flattering introduction, Loretta, or as Winston Churchill once said in another context, occasionally he stumbled over the truth, but picked himself up as though nothing had happened. Now, in the 1920s, when the great Al Smith was governor of New York State, he was invited to address the inmates up the Hudson River at Sing Sing Prison in Ossining, New York. The governor was a true gentleman, and he did not want to offend the assembled gathering of convicts. But he knew that he could not begin his remarks, as he so often did, by saying, "My fellow Democrats," nor could he say, "My dear friends." And all he could think of was, "I am so glad you are all here." And I am glad so many of you are here. And since this is about corruption, allegedly, there was this Irish engineer, and his name was Murphy. And he applied for an engineering position at an Irish firm based in Dublin. An American also applied for the same position. And both applicants, having the same basic qualifications, were asked by the department manager to take a written test. At the end of the test, both men had only missed one of the answers. The manager went to Murphy and he said, "Thank you for your interest, but we've decided to give the job to the American." Murphy asked, "And why would you be doing that? We both got 9 questions correct out of 10. This being Ireland and me being Irish, I should get the job." The manager said, "We made our decision not on the correct answers, but rather on the answer you missed." Murphy then asked, "And just how could one incorrect answer be better than the other?" The manager replied, "Simple. The American got the job, but you put down for your answer to question number 5. I don't know." That's what the American wrote. And you put down, "I don't know either." Now, if that had happened in New York and Murphy didn't get the job, he would have sued for employment discrimination in our court and probably would have won. But what Murphy tried was in a sense corrupt, and it gets me to my topic, which is your topic for these 2 days, which is corruption. And I'm going to talk about corruption primarily in the local criminal justice system and to a degree in government generally. Now, corruption in criminal justice rarely exists alone. Most often, it is a component part or an outgrowth of other criminal activity. For instance, one does not normally attempt to bribe a narcotics officer unless one is engaged in the business of selling narcotics. Rarely is there an attempt to fix a case in the courts unless some illegal enterprise has caused the defendant to be placed under the jurisdiction of the court in the first place. Many investigations arise out of or grow out of something that is integrally related to investigations into other ongoing crimes. Often these crimes are being committed by organized criminals. So organized crime, for instance, and I'm going to talk both about organized crime and individual criminals. Organized crime does not operate in a vacuum. Most organized criminal activity consists of continuing criminal enterprises which cannot be kept secret completely. Illegal bookmakers need bettors. Loan sharks need people who need money. And narcotic dealers, by their very nature, by the nature of the business that they engage in, they have to be available to elements of the public. And the criminal must provide his or her services, and therefore they become subject to the scrutiny of law enforcement. Once the lone criminal or the organized crime member realizes that he or she is being scrutinized by law enforcement, the potential for corruption begins or commences. One way by which the criminal seeks to lessen his exposure to the legitimate criminal process is by attempting to corrupt whatever segment of law enforcement the criminal can reach. To say it is more difficult in New York, I'm talking primarily here about New York, but this applies all through the United States. To say it is more difficult in 2019 for criminals to corrupt the prosecutors, the police, or other elements of the law enforcement community, is not to say that it cannot be done or even that it is the only option open. Attempts are still made, probably every day, to corrupt law enforcement. And sadly, some of these attempts are very successful. The fact that many would-be corruptors have both been arrested in the past, or that they have been arrested on a particular case, indicted and convicted for their efforts, has not dampened the enthusiasm nor that of their partners to corrupt. The interest and attention of criminals in some instances is directed, obviously, to non-police segments of the criminal justice system, such as the judiciary, the prosecutors, correction officers, in other words, prison guards, probation people, and parole officers. One true actual case that my office prosecuted when I was special prosecutor involved the head of the the head of the indictment bureau of one of the local district attorney's offices. The fellow's name was Norman Archer. And what had happened was that someone was arrested at Kennedy Airport who had flown in from Reno, Nevada, with a pistol. And the pistol was discovered, and he was arrested. And the case went before the Queen's grand jury, and the head of the indictment bureau, which is the bureau that presents cases to the grand jury, had the defendant who waived and testify that he had a license in Nevada for the gun. But he hadn't brought the license with him. And the prosecutor affirmed that indeed there was a license, and indeed the fellow had a gun. Well, there was no license. There was a gun, but there was no license. And he was tried, Archer was, and convicted and sent to prison. But that's one of the ways people try to get around. It's a lot more simplistic than the panel that Mr. McGuire was on earlier. But everyday corruption often is simplistic. And although there is perhaps and hopefully a decreased opportunity because of successful prosecutions to corrupt within the police department, the department has forced the corruptors and these efforts to try to make accommodations with other criminal justice agencies. That is to say, the criminals, if they can't get to the cops, they try and get to the other people further on in the system. None of the other agencies, however, is quite as important to the criminal as the police. The other parts of the process are not as important to the corruptors as the police, for the simple reason that other justice agencies don't generally exercise jurisdiction until after the police have made the arrest. The courts and prosecutors may be involved in the preparation or issuance of a search warrant or an electric eavesdropping warrant or order. But generally, the system begins with the cops, and the other agencies are involved in post-arrest activity. So the main thrust of the corruptor, particularly at the local level, and I'm sure this is so up in Ottawa, down in Sao Paulo, over in Dublin, and every other place in the world. The main thrust of corruption is to avoid arrest. The benefits in avoiding arrest are numerous. An arrest causes a number of problems that are irrelevant, completely irrelevant to the question of whether a conviction ultimately results. An arrest disrupts whatever operation the arrested person is involved in. An arrest often results in the seizure of important records. It's hard to run a major narcotic operation if you don't have the records. Every major narcotic case I ever tried, and I've been doing it now for 35 years as a judge, there are more records than IBM keeps. Now, an arrest by itself may force the movement of the site of the criminal enterprise. An arrest frequently causes valuable assets to be confiscated. All these problems cause something that the criminal dreads. What is that? A reduction in profits, a loss of revenue. So there is still another reason, of course, why the crooks would rather corrupt the police than the other criminal justice agencies. This has to do with the environment, as it were, in which the other agencies operate. The other criminal justice agencies function in a more open, in a more observable arena than do the police. This makes it much more difficult to put in a, quote, a fix, a close quote. At the investigative stage, the police operate in secret and in hostile surroundings. When a prosecutor declines to prosecute or a judge dismisses an indictment, reasons must be publicly given. These reasons are subject to review and public and media scrutiny. When a corrections official arranges special privileges for a defendant who is already incarcerated, this fact is not likely to escape attention and searching inquiry. I tried one of the so-called five families of New York, the five mafia families. I always used to refer to it as the merry men of the Colombo family. And the head of the merry men was a fellow who died recently called Carmine Persico, who his criminal partners, as it were, gave him a terrible name, Carmine the Snake, they called him. And that appeared in his obituary 6 weeks ago in the New York Times. And one of the problems with, not problems, one of the charges in the case was that Persico and some of the others didn't like the prisons that they were being assigned to in the federal prison system. So they bribed people to try and get moved closer to New York, because that's where the business still was operating, because it was one of the 5 families, and they didn't kill all the members. We only got 12 of them on that case. In any event, when a correction officer, a prosecutor, a judge is bribed or fixed or corrupted, it's more likely to become public than if it's the police officer, because he's operating essentially in secret. Now, of course, prosecutors decline to prosecute and judges dismiss indictments, and the reasons have to be publicly given. And when those reasons are subject to review and public and media scrutiny, it makes it much harder to corrupt. And as I said, when these correction officers arrange special treatment or privileges, it's not likely to escape attention and searching inquiry. But the police investigation that is unsuccessful often does not reach fruition or successful fruition from a law enforcement point of view because of corruption. And so the fact that there's an investigation and there's no arrest does not necessarily focus on the police. It often happens that there's no arrest. So as I stated earlier, the police operate in a hostile environment and in a sense in a more private environment. Their investigations are conducted on the home ground of the home field of the persons being investigated. And anything can go wrong in an investigation, as those of you in law enforcement know. An undercover may make an honest mistake. An informant may lose his nerve. The surveillance may be neglected to be made. And that's why the police are still the favorite targets of corruptors. There is less risk to organized crime and to the individual crook in corrupting the police. There is less likelihood of exposure. If successful, there is less disruption of operations, obviously, and there is less loss of revenue if the police are reached in the first instance. In recent years, there has been less opportunity, in a sense, to successfully corrupt the New York police because of 2 commissions that were put into existence by the then mayors. One was the Knapp Commission that went into existence in the early part of the 1970s, and the second was something called the Mullen Commission, which was put into place in the beginning of the 1990s. Both commissions were named after people who turned out to be, in Judge Knapp's case, one of the leading judges on our court. And the Knapp Commission uncovered significant corruption throughout the whole of the New York City Police Department. Those of you who are old enough remember reading about it, and it was, in those years, it was on television every day. They didn't have as many daytime programs, and much of it was in the winter, and there was no day baseball. And so anyhow, they watched the Knapp Commission, and that was named after a famous judge, Whitman Knapp. And the members of the commission were a tremendously distinguished group. The father of your first speaker tomorrow, Judge Preska mentioned that your first speaker tomorrow is going to be Cyrus Vance, the district attorney in New York County. Secretary of State Vance, his father, was a member of the Knapp Commission. One of our former late colleagues, John Sprizzo, who became a federal judge in the Southern District of New York, he was on the Knapp Commission. I don't know why, but I'm blocking on other members. Oh, no, Arnold Bauman was on the NOP Commission. He had been a member of the Southern District, a judge on the Southern District of New York. And the point is, it was a distinguished commission of impeccable people, and they uncovered this widespread corruption. And I had the pleasure of trying one of their main witnesses for 2 murders, whose name was William Phillips, and an attempted murder, whose name was William Phillips. Turned out that while going on Christmas Eve to shake down the house of prostitution, so most of you weren't born, it was Christmas Eve of 1968, and he went there demanding $1,000 to let the place continue to operate. It was a building on the northwest corner of the House of Prostitution, a large apartment on the 14th floor, 57th Street and 3rd Avenue, not far from P.J. Clark's, a famous New York watering hole where Mr. Phillips, the defendant, used to like to go to quench his thirst. And anyhow, the fellow who ran the establishment, we never found out his name. He was one of the victims. His name was either Smith or Goldberg. So he became a hyphenated name during the prosecution, Smith Goldberg. Anyhow, Phillips, who was a NAP Commission witness, had on Christmas Eve of 1968 shot Smith Goldberg and killed him, shot one of the prostitutes, a woman by the name of Sharon Stango, and shot and very seriously wounded a man who turned out to be the main witness, whose name was Gonzalez. He lived. And I tried the case against Lee Bailey, who then was a preeminent lawyer. And it was against Bailey. I got a hung jury. We tried the case again later on. He was convicted. It wasn't Bailey. In any event, the point is that the NAP Commission uncovered tremendous corruption. It brought down people very high in the department. And the Mullen Commission in the beginning of the 90s, which I mentioned, that was run by another judge, a former presiding justice of the Appellate Division of the Second Department, which is, for those of you who are not from New York, the Second Department covers Brooklyn, Queens, Westchester, and all of Long Island. And Judge Mullen was a wonderful judge and by then had retired from the bench, and he ran the Mullen Commission. And these 2 commissions made public the extent of corruption in the department. And as with everything, when things get public, the incidents decrease. We're now several years from the NAP Commission, and even less years, but still several years from the Mullen Commission. But they did result in a diminution for several years of corruption in the department, or at least that's the public perception. I hope it's so. Now, that effort to continue to reduce corruption and keep it at a minimal has to continue to be confronted and exposed, because you can't allow any safe avenue for corruption to open. But while we focus on the other agencies of the criminal justice system, we can't take our eyes off the police. And it's not that I'm anti-police, but it's just that that's the prime place to start in local law enforcement if you're going to fix cases. Now, the most famous corruption scandal in the history of New York State took place in the early 1930s when Franklin Roosevelt was the governor. And when a man by the name of Jimmy Walker, who they even made a movie about the case and about him, and they made a great Broadway play about the corruption. Then it was called the Seabury investigation, and Seabury was another fine judge. I was about a year or two old when this happened, but anyhow, Seabury ran this investigation and came to be known as the Seabury investigation. And how did it all start? It started because there was, apparently then magistrate judges were big deals in the city. There was a magistrate judge by the name of Ewald, or I don't know how you pronounce it, either Ewald, E-W-A-L-D. Somebody someday will tell me how to pronounce it. I call him Ewald. Ewald apparently bought his judgeship. And the price for the judgeship, depending upon what you read, and I've, going back into various records when Ms. Gill asked me to come here today, I added up the figures. At one set of figures for Ewald as to buying his judgeship came out to about $17,500 in 1930s dollars, 1930, not the whole 30s, just 1930. And another figure came out to 25,000. So somewhere apparently between 17 and 25,000 he paid to get his judgeship. Well, this brought down more than half, about 2/3 of the administration in New York City. And in a sense, it helped elect Roosevelt president because he was governor and he uncovered it. And it sent Walker off to Europe on a trip, having resigned from the mayoralty, and off he went. And I'll tell you a quick true story about that. Because a fellow by the name of O'Brien, I don't dislike the Irish, being of Irish descent. And as I explained to the young lady from Ottawa, I'm also a quarter French Canadian, but I'm primarily Irish. Nobody ever knows I'm French Canadian until I tell them. In any event, they made this great movie about Walker, and off he went to Europe, and O'Brien becomes the commissioner. And O'Brien is leaving the mayor's office under the new mayor, the interim mayor, and the press gathers around him, and they say, excuse me, I'm blowing my story. The mayor is O'Brien. He comes down the steps, and the press runs over to him. Who's your commission? Now, this is after they've cleaned up Tammany Hall and all the crooks and all the corruption. The press runs over to him and says to him, Mayor, who's your police commissioner going to be? To which O'Brien responds, they haven't told me yet. And that's a true story. And unknown, I think, to Judge Preska, O'Brien was the uncle of the wife of a former judge on our court. That was Vince Broderick's wife.
Oh, my gosh.
O'Brien was her uncle.
Who served as police commissioner.
Yeah. So anyhow, corruption has I guess the point is corruption's always been with us because of human nature. It reached its highest levels of our government in the United States. All of you are too young, even I am, to remember the Teapot Dome scandal. But that involved the presidency of Warren Harding, who was our 29th president. He had succeeded Woodrow Wilson in the 1920s. The Secretary of Interior under Harding, a fellow named Harry Doherty, I keep mentioning these crooked Irish. A fellow by the name of Harry Doherty made a fortune on illegal oil leases, particularly from one well called the Teapot Dome, and that came to be known as the Teapot Dome scandal. And Harding died very shortly after this was uncovered, and his death has always been questioned as possibly suicidal. You all know about Watergate. It brought down the 37th president Richard Nixon. And that, of course, resulted or was the break-in at the Watergate complex in Washington, D.C., of the Democratic National Committee headquarters, and that was during 1972, a presidential election year. The cover-up of the break-in resulted in Nixon's resignation from the presidency. The Whitewater investigation, or the Monica Lewinsky investigation, affair, as I'll call it, the affair, resulted in the impeachment of the 40th president, William Jefferson Clinton. Now, you know he was not convicted, but the impeachment forever stained his presidency, and as did the only other impeachment of the first president ever impeached. And there had not been an impeachment from 1867 until Clinton, and that was the 17th president, Andrew Johnson. And he was impeached over some silly argument as to whether or not the Secretary of War, which would now be, for those of you not American, the Secretary of Defense. It's the most important position in the government, except not elected, other in the executive of the government. The judiciary is just as important. The Defense Secretary is, of course, a tremendously important position, and his name was Stanton, and it was a question of whether or not Stanton's being removed from office was appropriately handled by the president. That wasn't the real reason for the impeachment, but that's why they impeached him. He wasn't convicted either, but Johnson was apparently somebody that was not, as my mother used to say, all wool. Now, so where does that all take us? I said, and I was at lunch the other day, I think Judge Preska was there with us, and where does it take us? Because as I was doing this in the outline for this, I was thinking, how do you end this talk? Because everybody in the room here knows about this. You probably know just as much or more about it than I do. But how do you end corruption? It ain't never going to happen. And the reason it isn't going to happen is because it's human nature. And the only way you're going to keep it controllable, as it were, is by public attention, public scrutiny, and as much as the press can be a pain in the foot and other parts of your anatomy, like my grandmother sat when she was first a bride, can even be a pain there. You have to rely on the press to uncover it. You have to rely on reasonable citizens to uncover it, and you've got to hope and pray that you get good, honest people elected so that they appoint honest people and good people. It's tremendously important. So I don't know that I have any more to say. If you have any questions, and I can confuse you by trying to answer, I will. Otherwise, thank you very much. Yes, sir. I'll take.
I wondered if you could share your views about former Mayor John Lindsay's leadership.
I don't want to make any political comments. I work for Ed Koch. As far as I'm concerned, he was the greatest mayor in my lifetime. That's my political comment. I thought Bloomberg was a very good mayor, too. I'm not going to comment about any particular mayor unless factually did something that was proven to be corrupt. I should say, in fairness to Lindsay, Lindsay did create the Knapp Commission. There would have been no Knapp Commission but for Lindsay, but there would have been no Knapp Commission but for the New York Times either.
I think that gentleman there.
Yes, I'm sorry, sir, yes. I don't hear.
Do you speak French?
He said that he's never spoken to a federal judge in his life, and he's honored to do so.
Oh, thank you.
He's just asked whether the judge speaks French.
No, I do not speak French, but I'm going to tell you a story after you finish. For the lady from Ottawa, and for you, if you're from Canada, I'll tell you, or from France.
But I'm not from I'm from Cameroon. But the question I was going to ask you has to do with your opinion on electing federal judges.
Electing judges?
Electing federal judges. What do you think about that's the first question. The second question is electing federal prosecutors. What do you think about it?
Electing federal
Whether or
prosecutors?
not federal judges should be elected, and whether federal prosecutors should be elected.
I think federal prosecutors and judges should be appointed. I think with the federal judiciary, as Judge Preska told you there in her opening remarks, we started with the federal judiciary in 1789. Over 200, what is it,
More than
25,
25.
more than 25 years. Over the 200 and more than 25 years, there have been very few instances of bad federal judges or corrupt federal judges. Very, very few. And frankly, our court is called, as she said, the mother court, because it's the first court to ever sit. And we've never had in the Southern District a corrupt judge.
In the mother court.
In the mother court. Yes, there was one in the Court of Appeals, but I don't talk about the Court of Appeals.
And just, may I say one thing?
Yeah.
So there was a federal judge in Florida who was
Oh,
found
yeah,
to be
well.
corrupt and who was impeached and removed from office. And do you know what happened then? They elected him to Congress.
And he's still in. No, and he's still in Congress. He's still in Congress.
Just to give you the sense.
He's been in Congress about 20, 25 years. Yes. Name is Alcee Hastings. Correct?
Correct.
Is there any other questions? All right, one more round of applause.